Hi, this is Marisa Portuondo, and this is the sixth video in our litigation series. And today I'm going to talk about written discovery. There are different types of discovery, such as depositions, written discovery, as I just mentioned. There are subpoenas, there's just all different kinds. But what I want to focus on today is the very common written discovery, which usually takes place soon after the answer has been filed by the defendant. So as we stated, the complaint was served on the defendant. The defendant will eventually have to answer that complaint. And once that happens, then you usually move on to the discovery process. Now, sometimes discovery goes out with the complaint, but for all intents and purposes, we'll just assume that discovery did not, and therefore it is being introduced after the answer. So there are three types of written discovery that the client, I should say, I was going to say the defendant, but it's the defendant or the plaintiff, so the client will be involved in, and that is known as the request for production, the request for admissions, and the interrogatories. These are, if you think about the names, it does make a little bit of sense, but I know it's a bit of a mouthful, so I'll go one by one with them. Now, the request for production. If your attorney files a request for production and propounds it, that's the word that's used, which basically means they just served it on the other side. What they're doing is they're requesting the other side to produce documents and things. So what are common things that are asked for in a request for production? Contracts, invoices, proof of payment, photographs, videos, anything like that. Anything that's in a document form or that is in any kind of tangible form can be requested in a request for production. When I used to do personal injury, we would see crazy things like, the plaintiff's shoes are being requested because, they need to be examined and make sure that the tread was still correct, and just all kinds of crazy things. So that's a request for production. Now, as far as the request for admissions, again, as it sounds, you are asking the other side to either admit or deny things. So for example, in a breach of contract, you would say, admit that you failed to pay the money that was owed. Obviously, you would, be a little more detailed about that, but that's a common, type of admission, and the other side has to either admit or deny it. Now, the final type that I mentioned is the interrogatories, and as it sounds, it's kind of an interrogation. And what that is there are written questions, and then the other side has to provide detailed written answers. Now, what's interesting about the answers to the interrogatories is that they're sworn, which means if you are the person answering, you will have to go and get the last page of those interrogatories notarized with your signature, and you are attesting, meaning you are testing to the truth of what you are saying. So it's basically just like testifying in open court, where you could be found to be committing perjury if you lie in these interrogatories. So as you can imagine, discovery can be extremely complex. It is probably the stage where the client gets the most involved, because there's a lot of the attorney, saying, hey, do you have this document? Do you have that document? We need you to come into the office. We need to go over these questions. You guys need to give us, the clients need to give us the answers. Clients get a little nervous because they think they have to get all lawyerly with their responses, but, we always take care of cleaning it up and making it, make sure the English is proper and make sure everything sounds, correct, but the actual facts of what is being provided, that has to be provided by the client. So, clients really need to cooperate and participate in this part of litigation. Now, again, as far as, the overall theme, we've been talking about how complex and how long litigation can get. As you can imagine, sometimes people don't want to give things up. Sometimes people don't think they should have to give things up. And this is where we begin to have a lot of the back and forth in litigation. So for example, you might request in a construction case, if we're representing the subcontractor, we will say, well, the subcontractor hasn't gotten paid, and the owner is saying, well, I paid the GC, and the GC saying, no, they didn't pay us. And so one of the first things we will request is proof of payment. Now, sometimes it's impossible to tell just by a check, from the owner to the GC, what work was that check for. So we might say, well, we need proof of all payments so that we can dig through this and figure out, did you actually pay for the subcontractor's work, or was this check for another subcontractor's work? The side representing the owner might say, hey, that's none of your business. What we paid other subcontractors, we don't think we have to provide that. And so they'll object and they'll refuse to provide that. The only way to go ahead and get that, if you can't get the attorneys to agree and the parties to agree, is to file a motion. We talked about motions earlier, and go up in front of the judge and argue that, it is necessary and that we do have a right to it. This happens over and over again in more complex cases, and there are numerous stages of discovery that can occur in more complex litigation. So you may have, your first round of discovery, a second round, then the other side has their discovery. I mean, it just keeps going on and on and on when there are very paper-heavy cases, when there's lots of facts and lots of players. The more complex the issue is, the more complex the discovery is going to be. So I hope that brought a little bit of clarity. I know this video was a little bit long, but discovery is a complex issue. As always, if you have any questions, if anything's unclear, feel free to reach out. You can ask questions in the comments and we will be happy to explain things. All right, thank you.